Good morning and welcome to PV Legal's daily newsletter. Today we bring you a landmark ruling from the Supreme Court of India that carries profound significance for anyone dealing with foreign exchange enforcement proceedings, and equally for those who believe that enforcement agencies must play by the same rules as everyone else. The case is J. Srinisha versus the Special Director, Adjudicating Authority, Directorate of Enforcement, decided by a bench of Justice Vikram Nath and Justice Sandeep Mehta on the 1st of April 2026. Here is the factual backdrop. The appellants, a distillery company and its directors, were accused by the Enforcement Directorate of acquiring and holding shares of a Singapore-based company, MS Silver Park International, without the mandatory approval of the Reserve Bank of India. This was alleged to be a violation of Section 4 of FEMA. The Enforcement Directorate seized the appellants' properties within India under Section 37A(1) of FEMA and moved the competent authority for confirmation of that seizure. Now, here is where the story takes a decisive turn. The competent authority, after examining the material in detail, found that the shares in question were never actually paid for. No call was ever made by the Singapore company for payment, and the ED had utterly failed to prove that anything of value was ever held in contravention of Section 4. The seizure was accordingly set aside by a well-reasoned order dated February 3, 2021. The Enforcement Directorate challenged this order before the FEMA Appellate Tribunal. That appeal was pending. Yet, and this is the crux of the matter, the ED simultaneously issued a show cause notice in December 2021 on the very same allegations. When the appellants challenged the show cause notice before the Madras High Court, both the single judge and the division bench dismissed the challenge. And worse, the adjudicating authority, relying heavily on the High Court's observations, passed a final penalty and confiscation order in August 2024, effectively overriding the competent authority's findings. The Supreme Court was unequivocal. It held that the competent authority's refusal to confirm seizure is not a mere procedural step. It is a substantive finding that the foundational reason to believe under Section 37A(1) was absent. The adjudicating authority, by disregarding that finding while the appeal was still pending, had effectively abdicated the powers of the appellate tribunal. This, the court declared, was arbitrary and contrary to law. The court set aside the High Court orders and the adjudication order, revived proceedings from the stage of the show cause notice, and directed the FEMA Tribunal to decide the pending appeal within 2 months. The message from the Supreme Court is loud and clear. Enforcement cannot be a one-way street. When the seizure itself fails the legal test, the penalty built upon it cannot stand. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant. Good day.